idea what's happening, but I think there's lots that has to be discussed. So it's already 50, but maybe there might be more people. So thank you, Heidi, Julie, for being part of the symposium.
Yes.
And of course, it was a pleasure speaking to you in the World Mediators Conference. So what we'll do is let's go straight into mediation legislation. Please, if you want to talk a little bit about yourself and the Consilium Institute, totally up to you. But then we go into that part. Yeah.
Okay, we have a short PowerPoint, which really is more of a placekeeper. If I may share that.
Yeah, please.
Okay. All right.
Jules, you don't have it on presenter mode. You have it on the whole thing.
Okay, let me try again. Sorry about that.
Before you try, Julie, just one second. What I'll do is let's just put up what we're doing. I think that's important.
Okay.
Also. Let's just put
Thank
up
you. Of course.
Oh, so we are doing this. This is mediation legislation. The how, why, what, who, when, where of it. And we're going into this symposium with a total open mind as to what we finally should look at, how it should be structured. But of course, in that phase, let's just find out what's happening in every country. So that was the idea. It's going to be totally an objective discussion. We're not stuck with anything that's happening. We can always look at it differently because finally everyone wants to promote mediation and see it work. So what are the issues coming up because of legislation, or what does legislation need? So let's look at that. So please, yes, Julie, now yours.
Okay, thank you. All right. Let's see, it says screen share is loading. There, can you see it now?
Yeah, we can see it.
Yep. Okay. Excellent. Well, I'm Julie Field, and I'm here with my partner Heidi Webb, and I would just love to introduce Heidi very briefly. And what we're going to be talking about is legislating mediation in family law cases, opportunities and obstacles. We're in the U.S. We have the Consilium Institute is the organization that we have founded that focuses on the bold answer to what's next in family law, which it really is focusing on how to do family law cases better. And we train lawyers, judges, financial advisors, and therapists in the Consilium process that Heidi created, which is an innovative approach to family law. Heidi and I are both mediators, and so we have that perspective as well. But what we want to talk about today is legislating mediation in family law cases, particularly in the US, and how that works. And I know that was a little bit of the discussion at the end of the last session in Turkey. And so I'd love to pick up on that as well. But Heidi Webb is a brilliant attorney, thoughtful scholar, an innovator in Boston area, Massachusetts, and she has done family law for many years, and used her counseling background to determine that there had to be a better way to assist her clients. And so she created the innovative Consilium process that she then taught to me, and I have adopted it and left my job as a judge to join her in founding the Consilium Institute. So I know we don't have a lot of time. I could go on and on about Heidi and how brilliant she is, but I will just tell you that you need to learn what she has to offer.
And I'll jump in here to tell you a bit about Julie, because she did allude to the fact that she'd been a judge. She was a judge for over a decade, for about 11 years. And before that, she was a professor, and she's a fabulous thinker, and she's been thinking and doing in the family law sphere for a long time. I think both of us have been doing this work since God was a boy. It is a real privilege to work with her, and our paths have crossed in many ways over the years. And she became just the obvious person to create the Institute with. And it's just an incredible privilege and joy to work with her and to develop the ideas that we've been developing over the course of over a year now. And to grow this. So mediation, we're both mediators. We both have a background in mediation, and she can certainly speak to it from her experience on the bench. And I can speak to it in the years I've done it, since what actually hearing about peer mediation at the end of your conversation on Turkey reminded me that I actually had been trained as a peer mediator when I was in about 7th grade here, which I was about 12 years old, I guess. But then in law school became a mediator, and had always incorporated mediation into my practice as a lawyer as well. So that's a little bit about us. And if you want to flip into the next slide.
Yeah, so let's talk a little bit about, just touch on Consilium and the Consilium Institute, the Consilium process. The Consilium Institute, as I said, is creating it teaches lawyers, judges, financial advisors, and therapists the Consilium process. And we have a community that we are building of people who are using this approach. And what it does is it looks at what does a family really need as a result of a divorce. And it really reconfigures the thinking about what does a divorce look like? How does someone get through the divorce process, and what do they need after? And the focus is using both a internal family systems model that Heidi innovated and applied to families, as well as a business restructuring model to think about what does the business of the family look like after the divorce. And we talk about restructuring families, and rather than divorce and separation and the negativity that goes along with divorce. Heidi, do you want to speak to that briefly?
Sure. I think as a lawyer, I got very frustrated seeing people get to the end of a divorce and say, now what do I do with my life? And it felt like they were so invested in the divorce process itself that journey sort of derailed them and detached them from growth in their own lives during that period of time. And it was really a stalled, for many people, it was many years before they reached the end point and then started asking questions that seemed to me should have been asked at the beginning, at the outset of their journey. And instead of being focused just on, for instance, a separation agreement, a division of assets, how the children would sort of maneuver between their homes with each of their parents, thinking more holistically about how long they'd be co-parenting together, and then building a plan, just as a business modeling plan, for maybe 15 years. What would it be like to co-parent with someone when love was no longer a commodity in the exchange that they had? So helping a family restructure became much more of a sort of holistic and long journey than just a divorce being sort of a moment in time, more of a snapshot than a video. And I think the question was really, how do we manifest that? And who are the players we need to do that? What other professionals do we need? Do we need financial planners? Yes. Do we need therapists? Probably yes. Like, what does that look like to put something together that really helps build a healthy, sustainable family model for people who are at the point you meet them at a really injured and sort of vulnerable place, in a vulnerable place.
Right. And the Consilium process applies whether the methodology that is used to get to the end of the divorce case is mediation, litigation. In the US, we have what's called collaborative law, which is a different process model. But what the Consilium process and approach does is it overlays on whatever court process, mediation process, dispute resolution process is being used in the particular family.
Does anybody have any questions? We do want to be interactive. If you have questions or you want to chime in, does this resonate or not?
Questions are going to come in when the legislation discussion starts.
Absolutely.
Consilium part, we're very happy with what you're doing.
That's fine. No.
But we wanted to let
statement.
And we agree, Vikram, we wanted to lay the groundwork, though, for the approach that we are taking. And one of the things that we really want to talk about and ask about and to think about is, when is it helpful to legislate mediation in the family law realm? When can it be helpful to a family? And what are the opportunities that can be created even if mediation is legislated, and when I'm saying legislated, I mean required by the court in most instances. Almost every state in the US, as far as I know, has a law that requires or allows for mediation in a family law setting. And judges are very happy to send folks to mediation because judges, rightly in many cases, but maybe not in all cases, see it as the way to bring the family together and resolve the disputed issues in the divorce. So I think there are some helpful pieces, and I'd like to start just a conversation there with when is it helpful to legislate mediation in the family law realm? And we'll also talk about when is it not so helpful. So anyone want to jump in and comment on that?
But I think the question here may be about the why. Why do you want to legislate in relation to family law? First of all, the why part of it, because there might be a whole history behind the government wanting to get into everything that you do. But are we today at the point when should they or should they not? I don't know. I mean, just a question, just throwing out questions. Let's see if what you think. But Julie's been on the bench. She has to maybe can tell us more about the why.
I think the why, absolutely. I think the why of requiring mediation is, again, that judges see it as a way of limiting the disputes in their courtroom, getting people to resolve issues. Mediation in particular, I think, is seen in the family law realm as something both by judges and often by lawyers here in the US and by many people as a better way to approach their case and their disputes. Now, that doesn't mean that it always works, right? It can, some of the helpful things, and Heidi, feel free to jump in here. I mean, we brainstormed some of the helpful things with requiring mediation, or a judge requiring mediation in a family law realm. It helps maintain privacy of the parties. It helps, gives folks a chance to address issues outside of the parameters of the courtroom and the rules of the courtroom that put people at odds with each other. It can the legislation itself or the court rules can help to set standards for who is an appropriate mediator and put guidelines around who could be a good choice of a mediator. Without that, you may not have the same level of guidance, at least for parties that are new to a divorce process. Heidi, anything you want to weigh in on that, just in terms of legislating mediation?
Yeah, and this, it's sort of two words are coming to mind, I guess. It's the point counterpoint. Is it healing or is it harmful? And I think there are times that it almost can be a court is rarely a healing environment. Whereas a mediation, because it can be an opportunity for people to hear more fully in a sort of a place where they're not navigating the terrain, but they have someone who's helping sort of facilitate a conversation that can provide a way for people to hear each other more carefully or more openly than maybe they can do on their own at that point. I think it can be very useful, But by the same token, if there's an imbalance in terms of the power dynamic, certainly if there's domestic violence, and we can talk about sort of other times that it's absolutely not appropriate, but I think there are times where people feel uncomfortable, unable to speak in a mediation, unsupported. And whether or not it's a lawyer-assisted mediation or it's two people and a mediator is a very different dynamic as well. There are different sort of ways that people mediate, and I think it's important to consider all of those elements when you're mediating. The other thing that I think the pandemic sort of made apparent to me was that mediation in a video environment is entirely different than it is in person. And I think that mediation as well, because there's a muting of the emotional strength in a video conferencing by virtue of the fact that it is more removed environment, both physically and the sound is different. People tend not to be as emotional. They tend not to scream or cry or yell, or all the things that can happen live in a room tend not to happen as often in a video conference environment. You don't get the same reaction and you don't have the same sort of emotional impact. So I think in some ways that's an advantage. Certainly when you're discussing finances or other things that are sort of like brass tacks, I think it can be really helpful to be in an environment that's sort of less emotionally raw. I think when you really want to do some deeper sort of emotional work, it's harder to accomplish that in a video conference environment. So I think it's, again, the flip side of both things. But
Heidi, do you think that online mediation should be legislated?
Yeah, so back to this whole legislated question, is it appropriate to mandate something that's voluntary?
No, only online. I'm just, you spoke about online, so I'm just looking at it because there is a specific country which is looking at how to legislate the online mediation. So how are you? How do you? Yeah. I mean, it just came in, so I thought maybe I'll ask you because you spoke about the online.
No, I mean, I think it's a very interesting question. I guess I think, again, there are times when it's just not appropriate because either of domestic violence or a situation that is really triggering for somebody. I've had people ask to mediate but have the video camera off. On the one hand, that can feel somewhat hostile, I think, because you're, especially if one person wants to be seen and someone refuses to be seen, it can be a manipulated environment, I think, in that way by some people. By the same token, it can offer something that may be better than either no communication at all or a phone call or, an inability to be present. I know I'm not entirely answering the question, but I guess I'm not 100% clear that.
No, why I've brought this up is because legislation and over legislation and those aspects of it need to be discussed, because there might be certain things, even I'm talking about online only because that the fact that you want to even legislate the way that online process has to happen, I think we're going to extremes. So in relation to legislation itself, we should question at every point of time whether this legislation is actually required in relation to every aspect of mediation. So I'm just saying open, because look, you're in a country where this has been happening for a little too long. I mean, there's been legislation for a long time. Countries are still picking this up and they're trying to do it. So that part of it, please put it across as to what you think are the issues in legislation in general and over legislation where all it's happening also, please.
Yeah, and let me speak to that from my experience as a judge. When the pandemic first happened, there was a lot of action around trying to legislate how court hearings could and should happen online. So I think analogizing that. I'm not quite awake yet. Analogizing that to mediation, that was resisted by the court because every court is different, right? And the court process is almost an easier one to legislate around, right? Because there are court rules. It is less although the judge directs the courtroom, there is less nuance and room to have different approaches in a courtroom than there are in mediation. So I think it is not appropriate. It's certainly not appropriate, I don't think, to over legislate even a rule bound setting like a courtroom. And it's certainly not appropriate, I think, to over legislate how mediation should be conducted online in particular. People who are trained in mediation and properly trained in mediation, as opposed to what happens a lot in the US, is lawyers say, I'm about to retire, I think I'll take some cases and do mediation, even though they were litigators their whole lives and never did a mediation course, never did a mediation except as a participant in representing a party. So they really don't know what mediation means. They think by doing a settlement conference, they are doing mediation. So I think to the extent, at least in the US, that mediation is regulated, legislated, guided, there has to be, I think, standards in terms of who an appropriate mediator is, what training they have. In Colorado, where I am, we don't have that requirement, and it is a bit of a free-for-all with these retired lawyers coming in and saying, I want to be a mediator, and not really knowing what they're doing. They're basically doing a settlement conference and putting people in separate rooms and going back and forth and saying, will you pay $20,000? No, how about 15? And that doesn't work particularly. That's not mediation. That's bartering, that's bargaining. And it doesn't work in the context where you're talking about what we talk about at the Consilium Institute is the nuances that you need in a family setting in particular.
I think, Julia, that's a good point you picked up, that first of all, we have to start with what is mediation. I think that was why my post, I put out the way I look at it, because the Singapore Convention, of course, the US has signed, Turkey has ratified it, India has signed it. So there was one place where a definition came up where so many countries in the world, at least in principle, agreed to a definition. So I put it out there only because let's start from somewhere. We have to start somewhere in terms of common understanding on mediation itself. Then when we move to a legislation, at least we know what are we legislating. So I think
and the legislation that you brought everyone's attention to, the UN agreement, focuses on commercial litigation, which makes sense in the international arena. But I think that most people, at least in the US, who experience mediation, participate in mediation, do so in a family law setting, because that is I think the most common way, and Heidi, you can disagree with me on this, but I think that is the most common way that people become acquainted with what mediation is. But if they are not really experiencing mediation, then or if they are ordered to mediation when it's not an appropriate fit, then they don't see it as a workable solution. They just see it as another box that they have to check for the court in order to get into court. And but when it works, then it can become an avenue, and when it's done right, then it can become an avenue that they can use in the future when they have disputes, and something that they can return to. So that's the pro and con is, different sides of the same coin.
Yeah. But I think the Singapore
first,
Heidi. No.
I was just going to say, as a very young lawyer, I remember before it was more integrated into, society, I'd say, as mediation being more of a ready option, more people sort of at least offering mediation as an option in family law. The courts would have mediators. There were a couple of mediators in the courts, and you'd go to court on a motion hearing and immediately be sent to mediation. What Julie was talking about before, judges sort of wanting to clear the docket and get as much of this done as possible. But the very premise of you having 45 minutes or an hour to resolve the conflict, or you go back to court, is sort of anathema to mediation. It's not a forum for really promoting a prolonged discussion with a neutral person who can help you navigate difficult terrain over a period of time. So I think that, that can be a very frustrating experience for the lawyers and for the clients when they feel like they're being forced to mediate in a litigation sort of paradigm, or you have to go to the judge. It's almost like, a kid being told, go to your room and think about it. And if you can't think about it, then we'll punish you afterward. So I think that's not so helpful, versus an environment where people are sort of willingly engaging into mediation over time with an agenda, with someone who's really skilled at trying to help people come to resolutions and decisions that will serve them well, as Julie says, over time, and model for them a system of communication that they can take into this next chapter of their restructured family.
Well, the only thing what I was coming back to on Julie, what you were saying about that the convention is about international commercial disputes. What the idea was, of course, the UNCITRAL was looking at the international commercial disputes, but they put out a model law, because when domestic legislation happens, you can legislate and say this will apply to anything for family and everything. So that's a expectation from countries that when they get the domestic legislation, and look, they can put out to enforce anything, not just the international commercial disputes, anything. But
and I understand that, but my point is, because it's created in this setting of the commercial world, how easily is the legislation that is being applied adapted to the family law situation? And I think that's an important question that each country who is addressing this, if that's where they want to go with it, needs to focus on.
Which we are going to try and answer here in the symposium itself, that what should that, if it's a good look, the 19th I had kept for that workshop. Let's look at a model law, and from every aspect, commercial, family, and everything. So we do that. Look, the problem is that people thought there was going to be a structured approach to your session, which I have disrupted. Please go back to your presentation.
No. Our presentation was more of a placeholder for us.
I think I was just going to say that I think, Vikram's first question, what is mediation, being the, essential question to ask before you start legislating anything. And then how are you applying it to what set of facts? I think that changes not what it is, but how useful it is.
Look, I'll tell you why. What I'm going to do, just for a second, I'll put out that definition that I had put out there from the Singapore Convention. And I'm saying, let's not take this as it is. We can start looking at it from that perspective. One of the words that I want to add, which I have added in the website on that word, mediation circle, is it says a process. I am saying we should write voluntary here, because of course, when they were looking at it in some countries, it might not be voluntary, because like in the court system, you might be pushed into it when you don't want to go into it, but you are. So but from our side, when we look at mediation, we should say voluntary, for one. Then it says with the assistance of a third person or persons. It should be with the third person or persons that they trust. Should not be someone, like you said, in the court system, someone you go to this person, there's a roster, so so-and-so will take up your matter. So we can expand on it. And then when we legislate, you know what you're legislating. So that kind of thing. So let's just open mind. We don't have to take what UNCITRAL gives us. We are open. We are not bound by anything. Yeah, sorry, Jilly. Now it's all yours. Please, I will not come in. I will, I will, but
and I am, what I love, Vikram, about your conversations and your sessions is that they are conversations, that they are provocative. So thank you for that. But, again, I was trained as a mediator. I did mediation before I was appointed to the bench. And I know that as a judge, the people who came before me saw a difference in how I approached their cases. And that was a constant refrain that I got in my reviews. And I think it is because of that mediation training and that recognition of autonomy that people need to have in a process that is deciding important things about their lives. And so I think that the mediation skills, I think that if we want to legislate mediation in any way, I think we should legislate that judges be trained in mediation before they take the bench, because I think that will also help them think about what they're doing, how they're doing it, and what agency people can and should have, even in a court process. And I'm talking a civil court process rather than a criminal one, whether that's family or commercial dispute.
But I'm not going to come in because definitely provocative concept is the training part, which I don't want to get into. That's one area which I have my thoughts on that.
Right.
On that
right.
part. I'm not going to get into it here. Of course, you will talk about legislating that part. I mean, if you have to legislate training and certifications and accreditations,
sure.
What should it look like? Should it be done or not? So please.
Mm-hmm.
Right.
So, right. Well, let me ask, do the folks here think that it would be helpful, appropriate, necessary to require anyone who's appointed as a judge to do we'll just say for now, commercial or family law, to be trained as a mediator prior to taking the bench?
Julie, the thing is that if training can give us Julie's mindset, if it can create Julie's mindset, I am all for training. And that's the only training this world needs. But it can never happen. We cannot get Julie's mindset at all through any training. It's a mindset that you had, you came with it. And no, if you could you might say that, yes, I went for a training and I really, from there, I brought this thing here. You did not. You were, when you were growing up, you had that mindset, and you, of course, brought that mindset on the bench or in your training. When you went into it, you took the mindset there and you connected with that training, because that was something that just was you. So I'm just saying, yeah.
Yeah, well, I'll just push back and say, because I think this is true. I think that we all have certain, like pre-programming. But if your standard is like a 10, like you're saying Julie's an 11, but your top mark is a 10, and you're starting with someone who's a 2, is it better to move them to a 5 or a 6 than to keep them at a 2? And I would say, there's some...
You can try, Heidi, you can try that mindset. You will not be able to shift from 2. There will always be that mindset. Look, there is some aspect of them which has been untapped, because there were certain circumstances in which they were working. Say a judge was told this is the way you have to go about it, and they've maybe watched a lot of movies and they thought this is the way they have to do. I don't know what they thought, but that's the way. But inside them, there was this aspect which then was in some way brought out in whatever way it could have happened. Ken Cloak he was a judge. And he then says that I went for a lecture about mediation and in 2 minutes flat, my life changed. Is because the kind of person he was. And that's when we went into his history and evolution of a mediator, because all that was him. It connected in that particular lecture that he went. But to say that lecture changed him and made him who he was, I think then we're giving too much importance to that part.
Well, I'll push back a little bit in that I think that it is possible to make changes. They may be incremental and they may not be, you're not going to create someone who is Julie, but you are going to improve the experience that someone has by exposing them to something that they may not have recognized as even possible. Not that it may resonate and be fully who they are. And I think we've seen that in trainings that we've done with people who are, for instance, really hardened litigators who say, I'm really not interested in sort of like this holistic, feels a little bit too soft. I'm a hard driving litigator. That's what I want to do. But I do see some credibility in this. This is interesting. Like maybe I can incorporate some of these skills into my practice. We have seen change that way. And I think that's useful.
Well, that's what I said. There's some people just because they're litigating lawyers, they think that's the way litigating lawyers have to be, and they went into that whole box that they were looked at. Look. You
Mhm.
think look at things around yourself. You look at things when you were maybe studying law. You do moot courts. There's a certain box which is going around, which of course is being
Right.
created in relation to mediation also now. So that box, you think this is the way I have to be. But then you find out that no, this is not the person I am. But then now you're stuck in this because that's the expectation from you, because other people are
Mhm.
also watching those
Mhm.
same
Mhm.
movies, and they're also watching other in the courtrooms, they're watching other lawyers and say this is the way it has to be, and that follows. So I think that person inside connected with it because the person had that mindset. But and it'll take time for that person to come out of that existing structure and say, oh, I want to practice things differently. You said collaborative law. I just find that really I don't like that terminology, because is there any
Yeah.
uncollaborative law? I don't know if there's
Yeah,
any.
no.
I used to, I,
We don't like that
Big C,
terminology
we
either,
don't
but that's,
exactly.
yeah.
We say big C and small c when we're talking about the
I
difference.
mean,
It's like, yeah.
so I think a lot of words can get thrown around, but
Yeah.
I mean, yesterday we were discussing this word, the concept called pre-litigation mediation. There is this concept,
Oh,
and I find
yes,
that
right.
really, I mean, it's not that means there's no correct understanding of what that process is and what goes after it. There's only you have a dispute, you attempt mediation, and after that there is litigation. Is there
Mhm.
something in between? Is everything, we are so focused this colonial mindset that everything is litigation. I think we just that by itself has to change. But I'm taking you into different directions totally.
No,
You know,
you're actually on some level you're not, because our approach at the Consilium Institute is that the family is more than the case. So it is a similar mindset, right? That the family is more than just the case and the court process. Whatever process you use, as I said, in the US, there is collaborative law, which is a very defined, rigid process that is supposed to create collaboration. But unless you follow that very strict process, you're not,
It doesn't,
I don't want to
yeah,
get into
it also doesn't,
yeah.
I mean, it doesn't really change sort of the premise of what you're trying to accomplish. It's just like a different
Right.
way of trying to get to the same place that isn't the right place to get to in the first place. The other thing I was going to say, in Massachusetts, there's a mandated, there's a letter that comes from the court in a divorce that says that you must explain to your client that they have the opportunity to engage in alternative dispute resolution. And what that usually means for lawyers is they say, oh, by the way, you could do this thing called mediation, but you probably don't want to. So let's stay focused on what I mean, it's just like not really being used in a useful way. It's seen by litigators, I would say, as either, well, it doesn't support their practice model, let's put it that way. So I think it tends not to be a suggested way to move forward, except as a sort of last resort when things aren't working well in their other sort of
because
worldview.
what we'll do is we can look at it first outside the court system. I mean, where something is not in the court. So in that kind of
Yes.
situation in the US, obviously that part is not regulated. So is that a good or bad thing? Should there be legislation on certain aspects or not? What should it look like? I think that's the basic kind of questions that the idea was to answer here, because you have years of mediation as in a formal kind of thing, but still this aspect not being legislated, which of course you will tell us good, bad, and the ugly of it.
Yeah.
Well, go ahead, Heidi.
Well, I was just going to say, there are states where, like in North Carolina, which is another state in the US that is, there is a mandated mediation component to all divorce, but it's sort of anathema to other aspects of the law there that are less progressive. So it's sort of like they have this thought about process as being sort of useful, I think, in many respects. But then there are other pieces of the legislation, particularly having to do with the family dynamics in terms of, whether or not there's been, adultery, whether or not there's been sort of whether people are penalized financially on account of their conduct is a big part of their law that's very different, say, from Massachusetts. So those sort of come up and rub against each other because, you know, on the one hand, you're saying you should mediate. On the other hand, you're saying, you know, or you must mediate. But on the other hand, you can file an action for compensation, financial compensation on the civil side of the court that counters what you're doing in the family law court. So, you know, those things are in conflict. So I think, you know, again, it's sort of like a fuller question of like, what are we trying to accomplish by the legislation? And, you know, how much does it fit into the bigger puzzle of this family, when it's a family law situation? How much does this help the entire picture moving forward? The children, each partner, you know, their rights, their responsibilities, you know, how does that all fit together?
Because I'll tell you why, how I'm looking at it, the way I look at mediation and the development of mediation, because when you talk to people in the US also, full-time mediators are rare. I mean, they're there. I mean, they're not rare, but they're there, but not so many of them. So what is the reason for that? We had to get into that. So now the aspect of saying that who can be a mediator, because like Julie also said about anyone coming in and saying I'm a mediator. So I am good with that because I feel it's a good thing that you can say that you should not be restricted, because who is there to say that, yes, you are a mediator or can be a mediator or good mediator? Who? People in dispute. There is no one else who can say that you can be a mediator, and they're the only ones who should have the power to appoint the mediator, because they are the ones who have to trust the person. So it's them. You can say whoever you are. You can say I can call myself a mediator, but no one trusts me to mediate. I'm not a mediator. So it's only the people in dispute. Anyone outside that, be it the government or the judiciary or anyone, to say we will tell you who your mediator is, and we've gone against the whole concept of mediation itself. For me.
Right.
So I'm saying that if you have to develop it, we have to put it out there that you have to, over time, get these people out, identify them yourselves, and they should be some people that you can say, okay, who's a mediator that you know? I mean, whenever you ask people about lawyers or doctors, normally you would ask someone, okay, do you know some lawyer who does this kind of work? Similarly, when are we going to be able to say, oh, do you know a mediator who does family law? And that's the person calls. You don't go to a lawyer, you call that person. And then that person reaches out the other side, maybe, or you reach out directly to the other side. So I'm saying, do we need to regulate or even legislate on the fact of whom you can appoint as a mediator? First, I mean, that's stage one. Let's look at that. Do you think?
Well, wait, are you saying, I'm sorry, but I just want to clarify, because I think that I hear you know, that only good mediators will be sort of engaged by people that they trust. But what's the credentialing for that person? And you're saying, I think that, you know, there isn't really a necessary credentialing. Either you're good at it or you're not. And I guess I would take a little bit of issue with that, in that I think it's important that the mediator has standards that they're abiding by in terms of confidentiality, in terms of neutrality, in terms of things that are really clear about what the expectations are, because I think otherwise people can sort of naively engage somebody's services as a mediator, liking their style, thinking they're competent, like all sorts of things could seem fine, but then 5 sessions in, things could blow up and that person, you know, I mean, if there weren't sort of requirements on confidentiality and, you know, I don't know, I can see that being problematic.
No, I'll tell you how I look at it, because of course a lot of this is spoken about, what about this person, ethical aspect and all those things. Trust, basically it's about trust. Now we say that this is an unethical person, but we push this person through a 40-hour training, the person is going to become an ethical person. I think
well,
it's ethics.
Absolutely. Yeah,
it's ethics. It's and to create that trust on every minute the person is sitting with you is gauging you, every aspect of what you do. So it's them to gauge the trust. And on the other side, we might say whatever, but how do you actually take that mediator to court if you have to say there was the confidentiality? Supposing, I'm just giving an example, confidentiality was breached. Who's going to go? Is the other side going to say, yes, this person breached confidentiality? No. Is the mediator going to say, I breached confidentiality? So now this just becomes an allegation you can put against anyone. Breach this, anything. I mean,
then you're back to litigation.
Yeah.
Right.
Okay,
Right.
these are thoughts we have to, of course. With me, the problem, like I said, you'll go into directions which might not be the ones that we were thinking of talking about. So please, Julie, again, let's go back to your presentation, your slideshow. Let's go.
No, that we don't need to go back to the slideshow. The slideshow really, honestly, was just a placeholder. But it seems to me what you're talking about, Vikram, are two things. You're talking about the when mediation, when people go into mediation, and ideally, whenever they, in a perfect world, whenever there is a dispute, people have a disagreement that they can't resolve themselves. How going to mediation would be that ideal outcome, right? That they would engage a mediator without thinking, oh, this is pre-litigation, I'm going to go to court, or be required by a court to do it, because by that point, they're already entrenched in a different way in the dispute, right? So the goal is the magical wish goal is that whenever there's a dispute, people would engage mediation without regard to court. We don't live in that world, at least in the US, because people always think of the stopping point for whatever their outcome is going to be. What would a court do in this situation? What would a court do? How would a judge rule? How would a jury decide? How would a judge decide my family law situation if the case goes to court? So I think that's the when. Ideally, absolutely, that they would that folks who are fighting with their neighbor would engage a mediator before filing a lawsuit in the court and being ordered to go to mediation, because even by that point, people are more entrenched in their position and feel more righteous about what they believe the appropriate outcome should be. So that's the when. And I don't know how we get to that world where people engage mediators. Most people, at least in the US, who become familiar with mediation at all or even know it exists is because they have been involved in the court and the court has required it. So how do we, and the work that you are doing is helping to create that world where people think of mediation first. And I am all about thinking about mediation first, because people are more satisfied with solutions they create rather than ones that are imposed on them by a court. And it helps the process of resolving the dispute to not have them be so entrenched when they come in to have that discussion. So that's the when question. The other question that you asked is the who question, and I won't go on to that. And Heidi, you wanted to say something, or maybe some of the other folks here want to add to that.
I would just say that, Vikram alluded to sort of the colonial aspect of sort of the litigation model. And I think the hierarchy of sort of how we see problem solving is tied to that to some degree. And it's sort of harkened back to, I was in Bali a long time ago and was talking to somebody about sort of resolving conflict and how they resolve conflict. And it was a system of elders. It was certainly nothing that was familiar to me as a young lawyer in terms of our construct. But I think that is, there are other systems, right, where courts aren't at the top of the pecking order. But I think here, part of what happens is without like a huge, marketing campaign on mediation, or even with it, I think you're talking about a culture that is somewhat tied to a model that you're just rubbing up against, because one of the things people often say here is that you mediate in the light of the law. So, again, the law is the standard, the court's the standard, the case law, the statutes, like that's sort of the model that people are using when they're mediating. It's not just we're sitting at the table and we're trying to sort of reach consensus through this process. It's in light of the law, because the alternative is to go to court.
Well, I tell you what, the thing is that all these symposia that I've done is because every stage is important. So I've discussed all the colonization and of course indigenous peoples to see what in terms of culture, and there was mediation in our culture and traditions, all that, to reach this point where Julie said, you want this ideal world. I'm saying, yes, if we want this ideal world,
I wanted to.
And what should legislation look like in that ideal world? I'm just looking at it from that perspective, because if if you want to create an ideal world and legislation goes against it, then there's a restriction there. And like I said, for me, in our discussions and the way I would want to, what the whole thing to progress, for that I know what I feel what kind of legislation is required. So I'm saying if that is not there and countries are legislating in a totally different direction because of that whole colonial mindset and all those things, it's going to come in the way of what I'm trying to create. So that's why this discussion.
Right.
Great.
Right.
No, it's super useful. Do other people have things they want to say to it? Royce, I see your
don't even do that, Roisin. If she comes in, then she'll be the only one saying it. So that's why it's her session after this. But I tell you, when you said about the Bali thing and the elders part of it, look, it is the way it is because there is something about the elder part of it. If you look at the CEDAR report, CEDAR took out a report now, an audit, whatever they call it. And if you look at that, they have given the age aspect of what the situation today is. Let me just put it up here. Just a table that they have put out. This is what it plays down today also. This is what it is. They did a whatever little sample survey. So that's what if that's the way it is, that's the way society looks at it anywhere. So you can go through all the structuring and everything.
Right.
And finally, that's what people want. So that's how.
Yeah.
So,
that's fascinating. Actually, that is fascinating.
Yeah. So I think there is a. That's why I go back to those symposia. Yeah.
Yeah. I will say, when I was very young in law school, I participated in a mediation model that was from New Zealand, and it was two mediators with two parties. And the model was really a younger and an older mediator. It was basically teenagers in conflict with their parents. And so they sort of paired a very young mediator with an older mediator, so that was sort of more relatable for each party. In the mediation, I thought was actually quite effective, negotiating sort of, many sort of cultural, there were this conflict between kids and their parents. Were often families who had immigrated to the US, and, the kids had very different idea of what they wanted to do than the parents' expectations were. And it was a pretty successful model.
But whatever you people had thought that you'll talk about, please do that now, because we have 7 minutes. So please go through that. I will not stop you from, because my direction will go into something else, which is that ideal world legislation situation. So.
No, the ideal world is exactly what Heidi and I are all about, honestly. In terms of the Consilium Institute, what we are all about is figuring out how to, in the family law realm, how to restructure families better. Mediation is one of those amazing tools that are available. And when done right and correctly, and with someone who is in their heart a mediator and probably has a little bit of training as well, is going to give them a better outcome than they would ever get by going to court and fighting over the calendar that their children will follow, which is often what we see here in the US. So, we see the pros and the cons of the mediation process that we have here in the US and how that impacts families. What we want is for families to become self-governing. That is the goal that we have in the Consilium Institute, is to create lawyers, judges, and allied professionals who will help a family become self-governing. Mediation at any point in that family dynamic, in that family process, when there are disputes, when there are needs for check-ins, just to make sure everything is going okay, is something else that we build in. Mediators are integral to that approach. So we are all about that that vision of having someone that a family can look to when they need help being self-governing.
So I think that's a good point, Julie. In terms of your objective that you have, is legislation coming in the way, or is it helping you in any way? What is it that helps? What is coming in between that objective? So that would be a good way of going about the legislation.
Yeah, and in terms of just to, put a fine point on the legislation piece, I think that the legislation, at least in the US, helps families get introduced to the concept of mediation, but it doesn't necessarily give them the right mediator, the right fit, the right process. And it's done, as we've been discussing, in the context most often of a court process that is imposed on them that may involve a mediator who really doesn't understand the need to restructure this family in a future-oriented way and get them to be self-governing. So it can be more harmful than helpful, but with Consilium, what we're doing is training lawyers, judges, mediators, and other allied professionals to have this same approach and the same goals. So if we can create our ideal world, you're working on yours, we're working on ours. I think there's a lot of overlap in what we're looking for and looking at, that this is what we envision as the bold way to approach family law resolution and restructuring in the US. And well, in the US for now, we'll take it worldwide later.
No, but I mean, like you said, I mean, is there any specific type of legislation that you would want to take this forward? What you want to do?
We don't. Sorry, I didn't answer the question. We don't need a specific type of legislation. One of the things that we've done with Consilium is to create a process that applies in any process. So an approach that applies in any process.
Yeah. And I think, just like you said, you can't sort of like make mediators in some way. You can't legislate sort of the personality, some of the sort of soft skill set that comes along with that. I think with Consilium, just to reinforce what Julie said, I think that because it's not legislated, because it stands outside the statute, it's something that it doesn't need to go through sort of the entanglements in the process in order to achieve the outcomes that are better for families. And, that's something that we strongly believe in.
Okay. So what we weren't able to get into is actually what are the various legislations that you have in the US, about the Uniform Mediation Act and all. So maybe because now Roisin is here and her session starts in 2 minutes. So any concluding remarks kind of thing, please. Heidi, let's go. Let Heidi didn't get too much of a chance.
Yeah, Heidi, I've been talking a lot.
No. I think you've been saying, everything that we've wanted to hear, but I guess I just think that, there are things that you can't legislate. And I think, legislating a style of communication and legislating a better way for families to resolve conflict is something that sort of flies in the face of what you're trying to teach. It's something that's more nuanced than that. And I think that, as Julie said, it's something that if you can introduce families to the concept of mediation through a system that they're more familiar with, I think that's useful. But I think beyond that, legislating that all families sort of do something that should be voluntary is sort of conflictual and probably not useful.
And let me also put it out that in the World Mediators Conference, you will find Julie in Heidi's session. You will get to know more about the Consilium process. So please do that. Of course, you can go to YouTube and search Mediator Vikram and write maybe Julie Field or Heidi Webb, and I think you'll find that session. Otherwise, the World Mediators Conference, the schedule is on my website. So I'll have to say thank you to both of you right now because Roisin is here and she doesn't have too much time.
Thank you.
She has lots to say.
So much.
She has lots to say.